Hello class, welcome to the ninth installment of Business Law Contracts. And we're still on the chapter that deals with agreement, and we went through the offer, we went through acceptance. I'd like to take a few minutes and talk about the area of electronic contracts or electronic agreements, right? Because many of the agreements that you enter into in modern life are electronic based. About 20 years ago, maybe 19 years ago, Congress passed the electronic signatures in global and international commerce. Global and national commerce. It's called e-sign. This legislation basically provides for the recognition of electronic transactions in the same way as paper transactions or oral transactions. Prior to that, there was a question as to whether one could effectively accept an offer, right, online, or whether that was an acceptable means of objectively showing that you intended to be bound. Uh, as a practical matter, the way that an electronic contract comes together is exactly the way that a paper contract or an oral contract should be together, will come together. There still has to be agreement, consideration, capacity, legality. So our look into electronic contracts, electronic contractual disputes will often center on the same issues as other contractual disputes. In a lot of electronic contract litigation, in particular, however, the issue becomes whether there was voluntary agreement, because the objective evidence, right, objective theory of contracts, there still needs to be some objective indication that the party intended to actually be bound by the specific terms that are in question. And that comes up in electronic contracts fairly often because of the situations in which electronic contracts arise. For example, Lauren wants to obtain software that will allow her to work on spreadsheets from her smartphone. So she goes ahead and she purchases Grid Magic. During this transaction, she has to click on several on-screen I agree type buttons you're familiar with to indicate that she understands that she is purchasing only the right to use the software and not the ownership rights. After she agrees to these terms, she can download the software, right? So this type of electronic agreement is called a licensing agreement. And had we not lost those weeks and been able to actually cover intellectual property, you would know that instead of buyer and seller in a licensing agreement, we talk about the licensor, meaning the party that owns the intellectual property, in this case, the software, and a licensee, which is the person who is granted permission to use the software. What's the difference between buying and selling? The difference is that the licensor still owns the software. You're just purchasing the right to use it, kind of like renting a car. And so that is one way in which electronic transactions come together. So one point to consider, if you are in a business and you are the party that's making the offer, for example, an online offer, right? So you make your offer, it's still the same structure. So let's say it's an internet offer, right? So one thing that we need to watch out for is to make sure that the terms of the offer are clear and understandable and don't contain a bunch of legalese. Why is that? Because we talked about the four types of ambiguity prior, and ambiguity, since you're making the offer online, if terms of the offer are ambiguous or unclear, that type of ambiguity is going to be resolved against the person that's making the offer, against that business, right? So that's the first thing to consider, right? So what types of terms need to be typically included? Generally, we need to be clear about all of those types of terms that would lend definiteness to an offer. Remember the qualities of an offer, right? One of them was that there be definite terms, and so categories. All right. Number one, there should be a clear acceptance of the terms, an area where they clearly indicate that they're accepting the specific terms that you've set forth in your offer document online, right? So, and that it constitutes the buyer's agreement to the terms, and it's generally a box that says I accept, or a button that says yes, or something like that, right? Payment should specify how goods are paid. If it's an instant transaction, right, then obviously the payment methods that are available. If it's online, paying with some type of card or credit card or debit card, that's handled right there. But those aren't the only types of payments that might be accepted in an online offer, right? If you have a return policy, or just as importantly, if you don't have a return policy, that should be indicated. Any disclaimers for certain uses of the goods. For example, they may add a disclaimer that says they don't accept responsibility for the buyer's reliance on forms rather than an attorney's advice. Like if you're selling a legal product, for example, like LegalZoom, right? If you were to buy an incorporation paper or something like that, there's probably a box that says, hey, you understand that this does not replace the advice of an attorney. That's known as a disclaimer. What a disclaimer does is it excludes a certain type of identified consequence or activity. It excludes that from the definition of a breach, because it's basically saying, it's not a breach. If you use this form and it doesn't meet your legal needs, you should know that this form does not actually replace the advice of counsel. Another one, limitation of remedies, or you could have a limitation of remedies clause. Sometimes that appears in the form of, say, a liquidated damages clause, and all that means is if there's a breach that occurs under this agreement, your sole remedy will be a refund of your purchase price and shipping costs, and maybe some other amount that represents maybe damage if it's a product liability type action to property. Those can be set forth, and they could be capped in a limitation of remedies clause. Privacy. You should probably have some indication, if you're collecting personal information, about how a person's personal information may be used, particularly if you are at an institution that might end up selling that to your customer list can be sold to other companies that want to market to people that are interested in similar products. So that as well should be included. And lastly, if you remember all the way back when we talked about litigation procedure, we talked also about alternatives to litigation. So if you would like to limit the parties to arbitration or to some other alternative dispute resolution technique like mediation, or to require mediation, then you can do so in that provision. In addition, these alternative dispute resolution clauses sometimes include a related clause called a forum selection clause. And a forum is simply a combination of venue under a possible jurisdiction. All right. So an example: before advertisers can place ads through Google, they must agree to certain terms that are displayed in an online window. These terms include a forum selection clause, which provides that any dispute is to be adjudicated in Santa Clara County, California. Lawrence Fieldman, who advertised through Google, complained that he was overcharged and filed a lawsuit against Google in federal court, district court in Pennsylvania. The court held that Feldman had agreed to the forum selection clause in Google's online contract and transferred the case to a court in Santa Clara County, California. Right? There still has to be jurisdiction, because a court can't hear a case that it wouldn't have jurisdiction over, right? But you can, if there's more than one jurisdiction, right, that could possibly hear a case, then it is possible to pick among those forums, to pick and choose. Brings up a number of potential policy issues, but it is the law. And the last one is a choice of law clause itself, right? So we haven't dealt very much with choice of law. It's not the most pertinent to your studies, but I should mention that the contracts that include a choice of law clause will specify that a dispute will be resolved in accordance with the law of a certain jurisdiction. Has nothing to do with where it's actually tried, right? So what this means is you could have a case in Maryland, right, that is subject to the choice of law of New York common law, right? And these are particularly common in international contracts, but they can also appear in other contracts as well. You should be aware of them. All right. Now, with regard to acceptance, all right, so we've got what we should have in the offer. There are some things that also need to be remembered in relation to acceptance, right? So acceptance is how a party agrees to the contract, right? By written or spoken words or by other action or failure to act. The UCC governs sales contracts specifically, has a similar provision to the common law, UCC 2-204. Again, that only covers sales of goods, which are a very particular type of contract, but just by way of comparison. UCC 2204 states that any contract for the sale of goods may be made in any manner sufficient to show agreement, including conduct by both parties, which recognizes the existence of such contract. And they've used these types of provisions to determine what constitutes an online acceptance. Because even though we've got under e-sign, we have this recognition of contracts in the electronic arena, there still needs to be an acceptance. We'll continue on with that after you guys answer the prompt and then click on the next video.